Howdy. Thank you for joining us as we discuss what type of legal disputes may arise around land ownership. Our presentation explains the type of lawsuits that parties may file to secure title to their land. This is an educational presentation brought to you by the legal clinics at the Texas A&M School of Law and the Landowners Association of Texas, with support from the Southern Risk Management Education Center and the United States Department of Agriculture. While this presentation offers information about legal issues, nothing here is meant to be provided as legal advice. There are various types of civil actions, or lawsuits, available to property owners who are unable to settle their disputes outside of court or who simply do not wish to. One thing we ask you to keep in mind during this presentation is that it does cost money to try and file or fight a lawsuit, so it's always best to try to handle these matters without getting the courts involved. The first type of lawsuit we're going to talk about is a lawsuit to establish adverse possession. Adverse possession is a legal principle that grants title of a property to a person who is occupying that property, even if the occupying person is not the legal owner and does not have title. There are 6 requirements that an individual must prove in court to make a successful adverse possession claim. The first requirement is that the individual must be in possession of the land. This means that the person must live on or use the land on a regular basis, as if the individual were the owner of that property. Second, the person claiming adverse possession must use the land in a way that is open and notorious. If neighbors of the property believe the person who is claiming adverse possession is the true owner of the property because they are so used to seeing the person interacting with the property in a way that an owner would, then that could provide proof that possession has been open and notorious. Examples of common use of property include frequent use of the driveway, using the front door, or working on the land. Ultimately, the land must be used in a way that is not so secretive that a true owner would not have known about it if they were paying attention to the property. Another requirement is that the claim must be adverse and hostile against the true owner. Now, this doesn't mean that you had to fight the true owner of the land. In fact, it is required that the land be acquired peacefully. In Texas, adverse and hostile just means that you're using the property without the permission of the true owner. The 5th requirement, a claim of right, basically means that the person seeking to establish land ownership through adverse possession is claiming ownership based on a reasonable belief that the property is theirs. The final step to proving an adverse possession claim is that the individual must be using the property consistently and continuously for the required amount of time. This doesn't force you to spend every second of every day on the property. It just means that you've been using the land in a way that the true owner would for all of those years. The time requirement in Texas can range from 3 to 25 years. 10 years is the default amount of time. The time requirement can get reduced if you have title and you are paying property taxes. It can get increased if you are trying to adversely possess the property from someone that is disabled, a minor, or deployed for military service. Only utilizing a portion of the land you are claiming could also add time. While we cannot cover all possible scenarios, we offer an example of circumstances that would reduce the time to 3 years. The owner of property A has a deed that correctly transfers property to him, but the deed incorrectly describes the land. The deed does not describe the solid black square around property A. Instead, it incorrectly describes the dotted rectangle that extends into property B. If the owner of property A uses the land that extends into property B and fulfills all the adverse possession requirements for 3 years, the owner of property A becomes the lawful owner of that small part of property B as well. This next example shows circumstances that would increase the time requirement to 25 years. Here, a woman has a deed that incorrectly or fraudulently transfers all of property A. The woman only puts a small part of the land to use in a way that meets adverse possession requirements. If the woman maintains the requirements for 25 years on the property of land, then the woman could have an adverse possession claim for all of property A. In addition to time, there are a number of fact-specific circumstances or considerations involved in a lawsuit to establish or defend against adverse possession. If you are involved in a lawsuit for adverse possession, we suggest you contact a lawyer for advice. Another common lawsuit to establish property rights is an action to quiet title. When others are out here claiming that they have an ownership in your property, a lawsuit to quiet title basically asks the court to tell all those other people, shh, and quiet their claims. It basically establishes ownership of the property to the true owner and can prevent others from challenging ownership in the future. Unlike adverse possession, it does not require physical presence on the property. A person bringing a quiet title action must establish the following. The person bringing the action has an interest in the property. The title to the property is affected by other interested parties' claims, and the other parties' claims, although seemingly legitimate, are invalid and unenforceable. So, you might be wondering what exactly we were talking about when we say interest. We aren't talking about you walking down the street and saying, "Ooh, that's a nice house. I'm interested in that property." Here, we are talking about a claim to ownership in that property. It can be just a portion of the property too. So you could have a claim to a large portion, like this piece right here that looks like a Pac-Man, or you could have a claim to a small portion that looks like a small slice of pizza. But either way, you still have an interest in the land. A quiet title action may be appropriate if the property did not get transferred properly from the previous owner, is in a boundary dispute, or when there are liens against the property. The third and final lawsuit we are discussing is a lawsuit to partition land. There's often land that is owned by multiple individuals, all of whom have legitimate ownership interests in the same piece of property. When multiple owners can't agree on how to divide their rights to the property, they can seek a court-ordered division of the property. This court-ordered division is referred to as a partition of property. There are two types of partitions, a partition in kind and a partition of sale. A partition in kind is a physical division of the property among the co-owners in proportion to each person's ownership interest. A partition by sale is a forced sale of the property with the proceeds of the sale distributed to the co-owners in proportion to each person's ownership interest. Now, partitions do have some problems. Some problems with the partition in kind is that sometimes the physical orientation of the property results in unfair divisions. In this example here, let's say Betsy got a piece of land that is further downhill than George, Jane, and Nancy. And let's say every time that it rains, all the rainwater rushes down to Betsy Smith's part of the land and it ruins her property. It'd be unfair to just give her the worst portion of the land and the other three people get the better pieces of land. Another example would be if a grandparent had 3 grandkids, and those 3 grandkids all had 3 families of their own. It would not be ideal to divide a single family home between those 3 families. Often, it is best to sell the property or otherwise buy out the other owner's interests in the property. Properties that go through a forced partition sale are often sold at below fair market value, sometimes as low as 50% or less of the market value, because they are not sold through the typical open market process. As a result, co-owners are often paid less than the real value of their ownership interest. Land developers have utilized this tool to acquire land from low-income and minority landowners. Texas saw that this was a problem. In 2017, the Texas legislature enacted the Uniform Partition of Heirs Property Act. This act seeks to remedy the serious problems many of those who own family real property have faced in keeping their property and their wealth as a result of the application of the default rules governing property co-ownership. It provides a set of coherent rules that try to address abuses that have arisen in connection with the partition of property that is owned by multiple owners. The Uniform Partition of Heirs Property Act helps co-tenants who want to hang on to their property in 3 significant ways. It requires that the co-tenants who are not seeking the forced sale be given an opportunity to buy the property. Courts must take the sentimental, cultural, and historical value of the property into account, as well as the co-tenant's special need to use the property. An example of a special need would be if a co-tenant would be rendered homeless as the result of a forced partition sale. It also appoints a disinterested real estate broker to list the property for a fair market value established by the court. Any co-tenant may initiate a partition action by filing a petition in the district court of the county in which the property sits. No statute of limitation applies for partition suits. Within the 10 days following the filing, the petitioner must post a visible sign on the property stating that a partition action has commenced while identifying the name and address of the court where it was filed. The court can require the plaintiff to identify themselves and all the defendants on that sign. The court will make a final determination about who the owners are and what percentage each person owns. The person filing the partition action, the petitioner, does not have to contact every co-owner, but that person must identify to the court all of the parties claiming interest that the person is aware of. Even if you don't know if they have a rightful interest or not, you still have to identify to the court anyone that will be trying to claim an interest. So, our key takeaways from this presentation are that having a valid will makes this process easier on everyone. You should communicate your position to other owners and the court. Also, consider resolving disputes outside of court, either by agreeing on a division structure or by agreeing to sell at a price deemed fair by everyone. Finally, speak to an attorney before taking any steps to begin a lawsuit. We hope that this presentation has given you a better understanding of the types of lawsuits involved in establishing ownership interests in land. Please let us know if you have any questions.